Good afternoon, everybody, and welcome to today's webinar on an advanced guide to writs of control. Just a few things before we get started today. We know from past experience that people often panic trying to grab screenshots of our slides. Please don't panic. The copy of today's recording, along with the slides and CPD certificate, will be sent out within about 24 hours of today's recording. So before we go any further, just a quick technical tour of the software we're going to be using over the next hour. You'll see there's a box on the right hand side. This can be minimized or maximized by clicking the white arrow in the orange box. And you can ask questions throughout the webinar and we'll try to address these at the end. Today you'll see that if you click the handouts option on the drop down, you should be able to download our ebook on writs of control. This is completely free and downloadable for you. Before we go any further, just to make sure everybody can hear us okay, could you please just type yes into the comments box? Good, fair few coming through. Looks like our sound quality is okay. If for any reason this does dip during the course of the next hour, please do let us know and we'll do all we can to pick that back up. So next, as always, a quick disclaimer. Please treat the contents of today's webinar as food for thought only. Don't take any action based on its contents unless you've taken independent legal advice first. The speakers cannot accept responsibility for any errors, inaccuracies, loss or damage unless we've given you personally specific advice relating to a matter about which you have given us the full background details for first. You should also bear in mind that the contents of this webinar are based on current English law, and because it contains archival material, the material is bound to go out of date at some point. So allow me to introduce you to our first speaker, Mr. Jason Wynne-Williams.
Good afternoon, everybody.
Jason is a business development manager within our group, and he's been with us now for just shy of 8 years. Despite his slender appearance and his boyish good looks, he is one of our certificated enforcement agents. Jason holds the Level 3 award in taking control of goods and is a current student member of the High Court Enforcement Officers Association. So he's working towards his Level 4 qualification and authorization. Jason is responsible for maintaining current business relationships and developing new business contacts. Jason's aim is to provide an education to new and existing clients to help them gain an understanding of the enforcement industry. And what have you done to me here?
Thank you very much, Sam. So what Sam doesn't know is I've added a birthday hat onto him today because it's his 52nd birthday, I think.
That's being kind.
Celebrating his 31st birthday today, so I'm sure everyone will join me in wishing him a very happy birthday. Much like myself, Sam is a business development manager within the company. He's got just over 7 years industry experience, and he's also responsible maintaining current relationships with existing clients, whilst at the same time trying to obtain any new business that he could get his hands on. Much like myself, he's got the Level 3 award in taking control of goods. He passed his Level 2 exam with an impressive pass rate of 97%. He's also a student member of the association, and he's currently on the education pathway to becoming a authorised High Court enforcement officer. Again, he's a certificated enforcement agent, and he's got a strong focus on delivering an education to all of the enforcement sector. Okay, so we're going to start off with a few polls just so we can gauge an understanding of who's in the room with us today. So you should see that poll on your screen in a second. First poll is a basic, have you previously registered for our basic writs of control webinar? It's a simple yes, no, or no, although I've got a basic understanding answer. Just give you a few seconds to answer that.
It's good to see that a fair few people have signed up to previous webinars. And those who haven't, looks like they've got a good basic understanding of the industry anyway.
Okay, I'll close that down now, thank you. So second poll question is, which best describes you or your company? Are you tuned in from a firm of solicitors? Are you a limited company or in-house legal team? Are you watching from an estate or letting agent? Are you a private individual, or do you come under the other box? So if you are classed as another, we just ask that you type into the questions box kind of what kind of industry are you from, what is your background. Again, we'll give you a few seconds to finish that off. Looks like the majority are either solicitors, limited companies. We've got a few local authorities or councils on board as well. Okay, close that down. Then final poll before we crack on with the main bulk of the webinar. Have you previously used the services of a High Court enforcement officer? Right, again, you've got three options. Either yes, you've instructed our company, High Court Enforcement Group. Yes, but you've instructed an alternative company. We're not going to be cheeky and ask who. Or no, you've never instructed previously.
There is method behind the madness, and the reason we're asking these particular questions is that it gives us a good feel for who's listening today, and it does allow us to tailor any future webinars or any further educational material that we do send out. We're not just being nosy.
Okay, so good 71% of you have instructed High Court Enforcement Group before, so we'll close that down. And then we're on to the main body of today's webinar. So I'll run through today's agenda briefly, just summarising. Now we're going to go into each area in greater detail further on. Obviously, this being an advanced webinar, it's going to be, well, try and be in a bit more detail than our previous broadcasts. So we'll start off with a little bit about our company, High Court Enforcement Group. Then we're going to move on to the pre-enforcement process and what do you need to do as a client in order to get instructions to us. The transfer process focuses on how do we transfer your case from the county court into the High Court. Sam's then going to go into detail on the different acts and regulations that we have to follow. That includes different stages of enforcement. So you've got the compliance period, you've got enforcement stages 1 and 2, and you've got the removal and sale stage. We'll look at our different powers of entry and powers in exceptional circumstances. I'll then move on to looking at exempt goods, third-party claims, and also tools of the trade claims for sole traders. And then Sam's going to finish off today's webinar with a look at some vulnerability examples and some general case studies that we've experienced over the past few years. So a little bit about our company first. So we were formed back in 2004. Now it was an amalgamation of all kinds of different companies from across the country. All the directors came together to create one big group. We're currently the largest independent privately owned enforcement company in the country, and we consist of kind of a group of different companies. So you've got High Court Enforcement. They deal with all the High Court writs, obviously, you process serving, things like that. You've got Excel Civil Enforcement, who will look after your council tax bills, your parking fines and similar. And then you've got National Eviction Team, who tend to look after the large-scale traveller squatter evictions all across the country, some of the ones that you may see on the news. Last year, we enforced just shy of 25,000 writs as a group, and all of our staff, they are pay-as-you-earn employed, and that hopefully gives us exemplary compliance, control and development of all our staff. Our team includes 17 authorised High Court Enforcement Officers. Within those, you've got the Vice Chairman of the High Court Enforcement Officers Association and also the Chairman of the Civil Courts Users Association. And we've got some quite good links. You know, we're fairly up to date with all the changes in government and regulations, and we update you as soon as we hear of any of that. So over the years, we've become synonymous for our unparalleled professional integrity, our ethical approach, and more importantly, our ability to deliver effective, proactive debt recovery service. So what are High Court Enforcement Officers? I assume some of you will have a basic understanding of this if you've tuned in previously. In simple terms, they're all authorised by the Lord Chancellor. Back prior to 2004, they were known as sheriff's officers, and you had 173 sheriffs in the country back at that point. Today there's only 44 High Court enforcement officers across England and Wales, so the numbers are diminishing. But of those 44, our group has 17 on our books. Each officer there authorised to enforce writs of control to recover any monies owed, £600 and above, and they can also enforce writs of possession in order to reclaim any land or property that's owed to you or your clients. At the moment, we can't enforce any debt that's regulated by the Consumer Credit Act, but who knows, that may change in years to come. I mean, it's not something that people grow up and say, I want to become a High Court enforcement officer. You know, there is quite an extensive study period that you need to undertake. You need your level 2, level 3 and level 4 diploma exams. Then have to complete a couple of years logbook with the High Court Enforcement Officers Association. That focuses on the taking control of goods, vulnerability, commercial rent arrears recovery, arrest warrants. Then you've got general business activities such as accounting, things like that. So it is quite, you know, an extensive training period until you become a High Court enforcement officer. So our core business then, our day-to-day bread and butter as we call it, is the writ of control, which is what we're focusing on today. The writ can be used to enforce county court judgments valued at £600 and above. Any cost orders that you can get, again valued £600 and above, and any employment tribunal or ACAS awards. Now these can be of any value. I think the smallest amount we've ever had to enforce was about £21. So there's no limit to those employment tribunal awards. Any orders valued at £5,000 and above, they have to go through the High Court. Anything ranging between £600 and £5,000, you as the creditor have got the choice. Do you want to enforce it through the county court or the High Court? The writ basically instructs our High Court enforcement officer to go and collect monies or to take control of the debtor's goods and then sell these goods to satisfy the debt, plus any costs that have been incurred throughout enforcement. It gives us a 12-month period from the date that we send the notice of enforcement out to the debtor. If we manage to get the case onto a payment arrangement, then the writ won't expire. It will just run out until the debt has been satisfied in full. The writ gives us the powers to attend premises any day of the year between 6 AM and 9 PM. That's at a residential premises, or we can attend a commercial premises during the normal trading hours. So as the client, there's many things that you have to do in order to get the case to the stage where you can instruct us. Now, we asked earlier on, where are you tuned in from? That's because each of our clients is different. We could get work from firms of solicitors, limited companies, estate agents, litigants in person, so you Mr. and Mrs. I know we've got some local authorities tuned in where we get a lot of work from debt recovery companies, cost lawyers, so it could come from any range of people. So first up, you're required to obtain either your county court judgment, your tribunal award or your costs order. That has to hit the correct value in order to instruct the High Court enforcement officer. So you can obtain your claim by logging on to the Money Claim Online website. So you can use the following link there that we've highlighted, or you can use the old school method of submitting the N1 claim form into your local county court. Now there is a fee payable to the court in order to process your claim, and this does depend on the value of your claim. Obviously the higher the value of the claim, the increased court fee is going to be. Something we always tell our clients, it's imperative that you look to sue the correct entity. Obviously, we can't enforce against an individual or a business that doesn't exist. So it's important to get your claim right from the outset. So how can you help us? In basic terms, the more information you provide us with on the debtor, the increased chance of collection. So if you've got any personal information on the debtor, things such as dates of birth, telephone numbers, email addresses, vehicle details, registration, we can complete DVLA checks. That increases our chances of either contacting the debtor, locating them, or locating assets that may belong to them. Any kind of background you've got on them, their employment status, their working pattern. Are they married? Do they have any children? Obviously, if we're aware of this information from the outset, then we wouldn't look to go and attend the property if we know the debtor's out at 9 AM taking the children to school. So it gives us the upper hand, and it increases our chance of contacting the debtor without wasting our time and your time. So the transfer process, this is just the basic information on how we escalate your case from the county court to the High Court. Now you can instruct us in a number of ways. We've detailed those below. You can send us cases either by email, by post, by DX, or for those clients with access to our online portal, you can send these cases electronically directly to our transfer team. Now, it's our transfer team, they complete all the court documentation on your behalf. All that we need from you as the client is either a scanned copy of the outstanding order. If you don't have that, you can just send us the basic claim details along with any information on the debtor that you think may assist us with enforcement. We do have a dedicated transfer department. They're based in our Liverpool office. It's their sole job to chase up any court delays and also to monitor the process in the crucial early stages. Obviously, any time we can cut down on increases our chance of catching the debtor at the address. Some of our established clients, we actually cover the £66 court fee that it costs to obtain the writ on your behalf. We can then send you an invoice. We can either do that on a case-by-case basis, or we can send you a statement at the end of each month if there's quite a bulk of work that's been sent. Again, it just ensures we're focused kind of on chasing the debtor and not chasing the client for payment before we send your case off to court. Now, in an ideal world, there is a transfer goal with this kind of timeline. So as an example, if we receive your instruction at our office today, let's say you email that into our transfer team, we'll then complete all the N293A documentation, which is the transfer up form. We'll send that to court the same day, providing that we receive it in good time. If you send us a case at 10 to 5 in the afternoon, it's unlikely we can get that to court the very same day. Providing everything's okay with your claim, the court will normally process the transfer in anywhere between 24 to 72 hours, depending on which court we use across the country. We then get all the correspondence back from court and we're obliged to send a notice of enforcement out to the debtor. Now, Sam's going to cover this in greater detail later. Unfortunately, this is the point where the case is kind of sat in limbo. We have to give a period of time for the debtor to make payment, and we can't enforce within that window. So you normally find between kind of days 3 and 17 is a bit of a limbo period where you won't hear much. We don't really hear from the debtor unless they're looking to make payment, and we can't actually enforce until that has expired. So you're looking at around day 18 onwards until our agents are physically out on the doorstep, making that knock on the door, looking to contact the debtor.
Gary's asked a question. Hi, Gary. He's asked if there are any plans to remove the £600 limit on enforcing a writ of control. Good question, and it's one that's kind of been a bugbear within the industry for as long as I can remember, and probably as long as Jason can remember also. There's been various lobbies and discussions to remove it, and depending on who you listen to and who you believe, something might come to fruition in the next couple of years. It might not, but it is something that the association and various enforcement companies are always looking at.
I think the reason for the limit as well, if for example you've got a debt of £100, Sam will look into our fee scale later. You'll start with a debt of £100. By the time we've been through the enforcement process, that could be anywhere up to kind of £1,000, £1,200. So I think the courts feel with the fee scale as it is, it may be a little unfair to send those smaller debts onto us at present, but that may change in future, as Sam said. So moving on anyway, I hope that answers the question. I'll pass you back to Sam. He's going to conduct a learning review with everybody, just to make sure that you've been tuned in and listening these opening few slides.
Thanks, Jason, and thank you for a look on the transfer process. So you should see the first question pop onto your screen now. Which is the earliest point a HCEO would be able to get involved? Is it at the point an invoice becomes overdue, once your claim has been entered onto Money Claims Online, or when a county court judgment has been obtained? Give you a couple of more seconds to answer that. It's good to see a very high percentage have got the correct answer. So if we close that down now, 95% of you are correct. when a county court judgment has been obtained. So the second question now, which of the following would a HCEO be able to enforce? Now there is more than one applicable answer here. Is it a county court judgment valued at £437, a county court judgment valued at £1,181, a costs order valued at £300, a costs order valued at £42,918, or a tribunal ACAS award valued at just £97? Like we say, there is a couple of correct answers here.
More than a couple.
Yeah. Okay, so if we close that one down, you've correct answers with the county court judgment valued at £1,181, the costs order valued at £42,918, and the tribunal ACAS award valued at £97. Obviously important to remember with that one that the £600 barrier doesn't affect the ACAS award. And then final question, what is the fee payable to obtain a writ of control? Is it £66, £75 plus VAT, £117.75, or does it depend on the value of the claim? Okay, a few more seconds to answer that, but again, good to see a good percentage of people getting that correct. So 94% have got the correct answer. It is £66 payable to obtain the writ of control. I think before we move on, Jason, did you want to take a question that's come in?
We'll touch on that when you cover it on your slide after, I think.
Okay. So next then, we're going to have a look at a couple of the acts and regulations that our industry adhere to. So these are all listed on your screen now. You'll see there's a number of them. However, the main ones that we're going to focus on over the course of the next 40 minutes or so will be the Taking Control of Goods Regulations 2013, the Taking Control of Goods Fees Regulations 2014, and the Taking Control of Goods National Standards 2014, which you'll see they are non-regulatory, but as an industry we do kind of stick to them quite strictly. So now we'll look at some of the time limits and extensions that are involved with the writ of control. So the Taking Control of Goods regulations does give a time limit of 12 months to take control of goods. And this time limit actually starts from the date the notice of enforcement is issued. It is no longer the seal date on the writ. So this also means that if we find a debtor has gone away or absconded from a property and we manage to trace them to a new address, under the regulations, we're then obliged to send them a new notice of enforcement. So that means the 12-month expiry does reset. We don't lose any time purely because they've absconded. We are able to extend a writ of control, but we can only do this once, and that's upon application to the court. And we'll have to list our reasoning why we want to extend the writ. That does come at a cost of £100. The alternative to that is to reissue a brand new writ, again, which will go back to the first cost of £66. However, should you choose to reissue and another creditor is waiting in line, then you would lose your initial priority.
You would.
If a payment arrangement is put in place, then the writ lasts for 12 months following the breach of any arrangement. So if there's no breach of that payment arrangement, then effectively there's no expiry date on the writ of control. So it does mean that where the debt is in a long-term payment arrangement, the creditor does not have to renew the writ each year, and there shall be no further expense to the client or the creditor. So if we have a look at the stages of enforcement, again, this changed in 2014 with the new regs. You'll see there's just 4 stages, and each stage now has their own trigger point. We'll look at the trigger points over the next couple of slides, but they are the compliance stage, enforcement stage 1, enforcement stage 2, and the sale stage.
So Gary may now see if someone's only got a debt of £100, you can obviously see how much that increases as we go through the stages, yeah?
So the first fee then, the compliance stage fee, this is £75 plus VAT, or a grand total of £90. So unlike the common perception, this fee is actually triggered upon receipt of the instruction and not at the point that the notice of enforcement is sent. So as soon as your instruction reaches the HCO, whether that be via post or email, the fee then becomes payable by the debtor. The notice of enforcement, that informs the debtor that a decision for enforcement action has been taken by way of taking control of goods. You'll see an example copy of this on the right hand side of your screen now, and you'll see that this details things such as the outstanding balance, the date payment must be made, and also the fees that will be incurred if payment is not made in full by the specified date. Now, when we issue this notice of enforcement, we have to provide the debtor with 7 clear days in order to make payment in full. Now, those words clear days, they're important because what it means is we can't include the day we post it. We have to allow 2 days for delivery, and then from there on we have to exclude every Sunday and any bank holiday that falls between. So those 7 clear days usually equate to somewhere around 13 days, depending on when it is sent. Now, in some exceptional circumstances, we can make an application to the court to reduce this notice period, but we'd have to plead our reasoning as to why, and that would be at the judge's discretion to do so. From past experience, the shortest I've known we've had a notice reduced to was just 15 minutes. And this was because we were looking to seize an aircraft that was landing in an airport. So we got that reduced to 15 minutes, served the notice, and it's needless to say that that was paid in full, otherwise that departing flight wasn't going anywhere.
That ties quite nicely into John's question. He's asked, does the requirement of sending a notice, has it resulted in quicker payment, or has it allowed debtors to hide their assets? Now, don't quote me, but only off the top of my head, I think the predicted compliance rate when the MOJ brought the new regulations in was going to be about 1% of debtors making payment. But am I right in saying it's just over this, or between 6 and 8%?
I think it's somewhere around that mark, again off the top of our heads.
Yeah, so it has resulted in an increased compliance from the debtors. If you have got an inkling that somebody's going to hide their goods, like Sam's mentioned, if you've got evidence of such, then you can make an application to court to get the notice period reduced. I don't think you can have it scrapped whatsoever, but like Sam said, the quickest we've had is 15 minutes. So I hope that answers that one.
Okay, so moving on then, the next 2 fees that become applicable are enforcement stages 1 and 2. So if we look at enforcement stage 1, this incurs a fee of £190 plus VAT, but then we can also add an additional 7.5% of any balance owed over £1,000. So if the debtor does fail to pay in full during that compliance stage, then the enforcement agent is obliged to attend the premises in an attempt to take control of goods. So if the enforcement agent attends the property and the debtor immediately furnishes us with payment in full, or they agree to an acceptable instalment arrangement, then the fees are simply capped at stage 1. However, if our enforcement agent gets to the property and the debtor refuses to make payment or to enter into an acceptable instalment arrangement, then we can immediately move to stage 2, all during the one visit. The only other time that this fee would be applicable is if we've entered into a previous controlled goods agreement as leverage against the debt, but the debtor defaults on any payments, then when the enforcement agent reattends the property, stage 2 will be applied. What you'll also notice with the fee scale is that the more involvement the High Court enforcement officer is required to have, the further the fees escalate. Obviously, if they pay during compliance stage, all they've had to pay extra is the £75 plus VAT. So again, the fee scale is there to encourage early compliance.
I think Keith asked as well, if a debtor stops paying, does the 12-month expiry start from the last payment? So that means enforcement stage 2 becomes applicable when they default on their arrangement. And yes, the 12-month period, it will reset from the date of their last payment. If they bring the arrangement back up to date, they may be paying us for a further 12 months, but then they miss another payment, so you'll get 12 months from that last payment. So it keeps resetting the clock each time they bring the arrangement back up to date.
So then we mentioned on the previous slide the controlled goods agreement. So the controlled goods agreement, this is a prescribed form by the MOJ, and it allows the enforcement agent to take control of goods as leverage against the debt whilst the debtor puts forward an offer of repayment. Now, our company, we would make sure that any instalment plan is agreed by you as the client. We wouldn't simply accept this on behalf. So that means if you're unhappy with the offer of repayment that's put forward, or you accept an arrangement and the debtor defaults on the payment arrangement, then the enforcement agent is entitled to reattend the property in order to enforce against the assets listed under the controlled goods agreement. Now, this controlled goods agreement, it has to be in writing and it must be signed by the enforcement agent and either the debtor, or if the debtor is not present, any person aged over 18 who is authorised by the debtor to enter into the controlled goods agreement. However, if we attend a commercial premises, it can be any person in apparent authority. So obviously if we're attending a large company or maybe a large unit or something similar, it's not likely that the director is always going to be on site. So we can take a signature or enter into a controlled goods agreement with somebody like a manager or perhaps a supervisor. The regulations do say that the enforcement agent may not enter into a controlled goods agreement with the debtor or anybody else where it appears they do not understand the effect of such. Effectively, it's a breach of the enforcement agent's powers and he'd end up in front of a judge getting a slap on the wrist. If peaceful entry has been gained and a controlled goods agreement has been signed at an earlier date, then forced entry can be used at a residential premises, providing the agent serves a notice of intention to re-enter on the debtor. What this does is it gives the debtor 48 hours to clear any arrears or the balance, and we must serve that notice by email or by hand. Now, looking at some of our powers of enforcement, again, these changed under the Taking Control of Goods Regulations 2013. And what they now say is that we can attend on any day of the week. So Monday to Sunday we can attend, but we do have to be mindful of religious holidays. We have to take those into consideration. At a residential address, we can attend anywhere between 6 AM and 9 PM. However, where the premises are used, whether wholly or partly for a trade or business, then the enforcement agent can enter the premises during the opening hours. So an example of this might be if we're enforcing against a nightclub, which is open until 3 o'clock in the morning, it might be wise for our enforcement agent to attend at 3 o'clock in the morning when the tills are full of cash and we're likely to make a full recovery. So the enforcement agent may only enter the relevant or specified premises by any door or any usual means by which entry is gained. So we're going to look at usual means over the next slide, but forced entry is only a possibility from the outset at a commercial premises. And this is only if we believe the assets within are likely to cover the balance owed. It is no longer possible for an enforcement agent to gain access to a property via an open window or a skylight, which is still one of the common misperceptions. So exceptional circumstances. Now, in some circumstances, it is possible for the enforcement agent to use an alternative means to gain entry to the property. However, they are very few and far between, and they're not examples that we come across very often, and they're usually dependent entirely on the individual scenario. So we did speak about usual means on the last slide. You'll see this photograph on the right-hand side. Again, real-life example that one of our enforcement agents took. You can see that the debtor's barricaded himself within. Now, in this example, he was actually using his kitchen window to gain access to and from the property. So it begs the question, was this now his usual means of entry? I'll leave you to ponder on that one. It is also possible for us to make an application to the court to request permission to force entry into a residential or a third-party premises. However, we must justify this application, and if there's supporting evidence available, we'll also have to supply this. Examples of this would be where we know the debtors maybe hiding a luxury vehicle in a garage around the corner or elsewhere, or if we know there's valuable antiques within that we know are likely to cover the balance. Unfortunately, the order is at the judge's discretion, so despite all the supporting evidence, there's no guarantee we would get it. But the Taking Control of Goods fees regulations do also allow for disbursements such as locksmith charges to be applied on top of the debt if we do force entry. These also become payable by the debtor. So at this stage, having covered stage 1 and 2 in our powers of entry, I'm going to hand you back over to Jason, and he's going to look at the sale or disposal stage, immobilisation and removal of goods. Jason.
Thanks, Sam. I think before I go into this one, Peter's asked the question, is there a way to reduce the 48-hour notice on the, well, we call it the Form 6, is what we have to send if they're in breach of the CGA, and that's in order to prevent the goods from going missing. The Form 6 that we send out, it doesn't actually list the goods that we're going to go back and take. It just says that payment has to be made in order to stop a reattendance and us entering the premises to remove goods. It's a prescribed form by the Ministry of Justice. So I don't believe that at the moment there is actually a way to reduce that period. If there's any consolation though, I mean, from the point that judgment is granted, the goods are supposed to be bound to the debtor. So at any point throughout the enforcement process, if there's evidence that the debtor has hidden goods in order to avoid us taking those and selling those, then they could be found in contempt of court, and that opens a whole new barrel of worms for the debtor. So if we take a look at immobilisation and removal, it's actually less than 1% of the cases that we deal with that reach this point. It's normally just the threat of removal that is enough to prompt payment from the debtor. However, if it does get to that stage, there are further fees payable by the debtor. You've got a basic enforcement fee of £525 plus VAT, so that equates to £630. But then over and above that, you've got an additional 7.5% of any balance owed over £1,000. So should it get to this point, there are additional notice requirements, both where the goods are immobilised and when the goods are removed for sale or storage. So if we talk about immobilisation first, if we see a vehicle that's parked up on the highway, so either on a street or not at the private residence of the debtor, we can clamp this vehicle, provided we've got knowledge that it's owned by them. We then have to give them an additional period of 2 hours in order to try and source funds to try and discharge the balance. It's only after that 2 hour period that we can think about commencing the removal. Now, if the debtor comes to us after 10 minutes and says, I can't get the money, here are my keys, that's fine. We can look to start from that point onwards. But if the debtor doesn't contact us, we have to wait a minimum of 2 hours for them, to at least understand the vehicle has been immobilised and give them the option to make payment. When we then remove goods, there's more prescribed forms that we have to complete. We need an inventory of goods, and a good example of this, it needs to contain the enforcement agent's details, dates of visit, any reference numbers that are relevant. It needs to give a detailed breakdown of the balance along with any outstanding enforcement costs. We also need to list the manufacturer, any models, serial numbers, and also the colour of goods. Now, we should be provided a valuation of any goods that are removed. For any specialised items such as aircrafts, boats, even Formula One cars that we've dealt with in the past, we can call in a qualified independent valuer to kind of give us an independent valuation and a more realistic value of what those goods are worth. And it's important to note that whilst any goods are under our control, the High Court Enforcement Officer does hold responsibility, and they have got a duty of care for those goods. So if there's any damage to assets, or if any assets go missing, then ultimately it's our shoulders that responsibility stops at. So we'll move on to the sale of controlled goods once they've been removed. So the regulations advise that goods should be sold at public auction unless an application is otherwise made for a court order stating otherwise. An example again, you've got the luxury items such as an aircraft or a yacht. These are going to be worth, anywhere up to tens of millions of pounds worth. So you're not going to get your best price at public auction on these goods. So we can sell them by private treaty, where we'll have individuals sending sealed bids, and it will go to the highest private bidder. We must provide the debtor a minimum period of 7 clear days. Again, this is similar to the notice of enforcement we send at the start. This is called the notice of sale. It gives the debtor information such as the time, place, date of sale, and it will give them a deadline and an outstanding balance if they wish to make payment in order to get their goods back. We have to serve this on the debtor by the usual means, so post, hand delivery, fax, or any other electronic means such as email. We are entitled to charge the debtor disbursement such as storage fees, locksmith fees, court application fees, and any exceptional disbursements, providing that they have actually been incurred. So an example, heavy machinery within a factory, it's all bolted into the ground. We need specialist engineers to come in to remove those goods. that would then class as an exceptional disbursement. It can be added on top of the balance. It can be taken from the sale proceeds following the auction. However, if we can secure the goods on site and the auctioneer is available to host an on-site sale, this could keep costs to a minimum. So we use the factory machinery as an example. You may have other businesses, companies coming in to bid on site for that machinery. Then once the auction is finished and title has changed hands, the onus is then on the new owner to remove those goods, so that effectively they would pay the cost of removal. So on a day-to-day basis, we do come across various goods that are exempt from our enforcement powers. Sam likes to call this the common sense list, which I kind of see. In simple terms, we've got a duty for care not only for the creditor but also for the debtor. So we have to leave them with enough items to satisfy their basic domestic needs of them and also every member of their household. I'm not going to go through the complete list, but you see common sense items: cookers, refrigerators, washing machines. You know, we're not going to remove their bed and bedding. Who's going to turn up at auction and buy bedding, second-hand bedding? It's not going to raise much money towards the outstanding balance. Anything that's required for the medical care of the debtor or people within the household, or anything that's going to affect their safety, such as a CCTV system, we couldn't uninstall this if the property was in an area of high crime, because it could leave the debtor vulnerable then. Again, common sense, we can't take any guide dogs, hearing dogs, dogs for disabled. A few things maybe outside the box. You still can't remove sheepdogs, guard dogs, or domestic pets. If we've got evidence that they're using the domestic pets for breeding purposes and to generate an income, then we could potentially take those because they're not being used as a domestic pet. Any vehicle that displays a disabled badge, or where we've got reason to believe that is used to transport a disabled person, we can't touch those vehicles. And likewise, any kind of vehicle where there's a hint it may be used for emergency services, anything such as a private ambulance, they're also exempt from enforcement. Now, if we stick on the theme of exempt goods, but this is the tool of the trade now. So the regulations above, I've highlighted the kind of important areas. So basically, any items which are necessary for use personally by the debtor in the debtor's employment, and the value shall not exceed £1,350. So we've got the toolbox here. I've highlighted it in red because the likelihood of that toolbox being worth more than £1,350 is unlikely. Therefore, the debtor could claim that as a tool of their trade. The van in the middle, that gets an orange highlight because the debtor doesn't necessarily need a brand new Ford Transit van to conduct his or her business. They could drive around in a small, old, 5-year-old commercial van worth £1,000, which means they then could claim that vehicle as a tool of the trade. Anything over that value, so a brand new transit van, that would automatically be exempt because the debtor doesn't need a £10,000 van to conduct their business. We would need to cite evidence of insurance documents just to prove to us that the vehicle is being used solely for business purposes. If there's any domestic or pleasure use on there, then it isn't classed as a tool of their trade and we could look to take that item. Right hand side is fairly basic. We've got a large kind of JCB excavator. I don't know how much they're worth, maybe 60, 70,000 pound. So easily that falls above the £1,350 threshold to become exempt as tool of the trade. It's important to note that a limited company, they're not able to claim that any goods are exempt under tools of the trade. Effectively, it's the limited company that have got themselves into debt, so it's the limited company that needs to get themselves out of debt so we can take their assets. Moving on to third-party claims, it is quite common that when we're looking to either take control of goods or remove goods, that a third party may claim these items. Now, the claim could come from any number of sources. It's not just restricted to the below, but majority of times you do find that they either come from trade suppliers, finance company, family members is a big one, and again, either a company or director or vice versa, depending who we're looking to enforce against. Now, the third party, they may want to claim all goods that are at the premises, or they may only have a few items that they wish to lay claim to. Both the High Court Enforcement Officer and the third party, they must follow the correct procedure within the civil procedure rules in order to deal with the claim. We don't have to physically remove items for a third party claim to be submitted. It can be submitted at the point where we create the inventory and enter into a controlled goods agreement. Now, as per the civil procedure rules, it's not for us as an enforcement agent to admit or dispute the claim. We have to pass everything over to you as the creditor for you to make the decision. I'll go into a little more detail on that now with third-party claim procedure. It's CPR 85.4 if you wish to have a look in greater detail. It's for claims to controlled goods. Now, as soon as possible, the third party must submit a claim. If we have removed items, it has to come within 7 days of removal. Obviously, that ties in with that notice of sale period that we give to the debtor. Their claim must also include the following information. They must give us their full name and address, and a confirmation that that address can be used for service of documents throughout the claim. They need to list all goods that they're looking to make a claim to, and the grounds for which they want to claim each item, receipts, evidence, invoices, any kind of supporting evidence they have. Within 3 days of receiving the claim, we have to give notice to the creditor and also to any other person that has a claim to the controlled goods. So a warehouse full of goods, you may have 3 people looking to make claim to items, so you'd have to advise all 3 people. The creditor then has 7 days to look over the claim and then make a decision, give notice to the enforcement agent as to whether they admit or dispute the claim. Now, they can admit this in whole or in part, it's entirely up to them. We can't influence their decision whatsoever. Once we've had the outcome, we must then inform the third party within 3 days of receipt of the outcome. If the claim is admitted, we must release goods back to the third party. Now, it doesn't say we have to return them, it just says release. So if these are stored at public auction, we'd simply write the third party a release note, and the onus is then on them to go and collect their items. If the creditor decides that the claim is disputed, then it's up to the third party to make an application to court. It's likely that the case will be heard in front of a judge, and often the judge does ask that the value of goods are paid into court so that they can argue over the money element rather than the goods sat in storage incurring further costs. So that kind of covers the enforcement and removal process. I'm going to pass you back to Sam now. He's going to touch on kind of managing expectations and also the vulnerability aspect of our job day to day. So Sam.
Thanks, Jason. I mean, what Jason's modestly failed to mention during the past couple of slides is that he was previously our head of removals, so he's well experienced to be covering this area of enforcement.
Thanks, Sam. Don't like to brag.
So yeah, we'll look at managing expectations. So this is a question that we often get asked, most commonly by litigants in person or those who are new to instructing a High Court Enforcement Officer. From the poll at the very outset of this webinar, it's good to see that there's a vast number of the people in the room today who've got experience. But if we look at the statistics released by the High Court Enforcement Officers Association, you can see that back in 2014, collection rates were just over 25%. That grew in 2015 to 29.5%. The reason for the growth, I couldn't really give you a direct answer, but you could probably largely put it due to the regulation changes in 2014 and the various enforcement agents and companies becoming more accustomed to the regulations. Again, in 2016, unfortunately, that's the last information that's available. That rose again slightly to 30%. But what you'll note is that really only 3 in every 10 cases are paid. And that's because there are a number of factors which do affect the chance of recovery. And it's important to know your debtor before you look to instruct a High Court Enforcement Officer. It's worth asking questions or looking at the debtor and thinking, are they employed? Do they have a regular disposable income? Do they own any assets of value? Or do they maybe suffer from any mental or physical disability? As High Court Enforcement Officers and enforcement agents, we require 3 things. From the very outset, we need the debtor to be residing at the property that we attend. Secondly, we require there to be money available. And if there's no money available, we require there to be assets to the value of the debt in order for us to take control of. Obviously, if the debtor has no money, because maybe they're on universal credit and they're living day to day, or they have no assets of any value. Obviously, our job then to recover your outstanding balance becomes more difficult. For an example, it's always going to be easier for the enforcement agent to recover £1,000 from an active trading company than it is to, say, recover £5,000 from somebody who's unemployed and struggling. So if we move on, we'll look at the cost of instructing the High Court Enforcement Officer. So there's only really two costs that you need to concern yourself with. The first of which, unfortunately, there's no getting around, and that's the cost to obtain the writ of control. Now, this will cost you £66. However, where we are able to make a full recovery, we will recover that £66 back for you, along with 8% interest. Like Jason mentioned at the start of the webinar, for established clients, we're happy to pay this on your behalf and then send an invoice with 30-day payment terms. Now, we can either do that per instruction that you send in, or either monthly, if you've got a couple to come through the month. All the work involved in completing all the documentation and the application on the N293A, chasing the court, all that work is complimentary as part of our service. And then the only other fee is the old abortive fee, now known as the creditor's guarantee fee, of £75 plus VAT. So if enforcement has been wholly unsuccessful and we've been able to gather any monies from the debtor, then under the Taking Control of Goods Fees Regulations 2014, we are able to charge a small fee towards our service, which is £75 plus VAT. However, if we have received a small portion of monies towards the debt, then obviously we'll adjust our invoice accordingly in line with that. So for those of you who have tuned into our webinars before, you'll know that we've spoken largely about vulnerability. This remains a hot topic within the enforcement industry, and previously the royal family have made comments on the potentially vulnerable within our society. Now, this falls under the National Standards for Enforcement Agents, and it doesn't actually give a definition of vulnerability. But what it does do is give a list of those who might be classed as potentially vulnerable. And that list includes the elderly, people with a disability, those who are seriously ill, whether that's physically or mentally, the recently bereaved, single parent families, pregnant women, unemployed people, and those with obvious difficulty in understanding, speaking or reading English. Now, we have given two examples on the right hand side. So we've got Madonna, who is a single parent to a number of children, and we've got Pierce Brosnan, who is 65 years plus, eligible for his best pass and would likely fall into the elderly category. Obviously, I'm sure you'll all agree that neither of these two would have any difficulties in managing their finance, or should any debts land at their doorstep, would they have any troubles paying them? So just because people may fall into these categories, just by definition, it doesn't make them vulnerable.
The audience views just dropped down to 30% whilst everybody Googles the age of Pierce Brosnan. So.
Yeah. What the regulations do say is that the fees or fees due for enforcement are not recoverable unless the enforcement agent has given the debtor an adequate opportunity to get advice and assistance in relation to the exercise of enforcement power. So in essence, what we have to do is allow that extra time to the debtor for them to contact the CAB or Step Change or similar organisations for them to gather that advice. Obviously, this information isn't always known to us at the outset of enforcement, and sometimes it isn't until the enforcement agent attends the property do we know that there's a potentially vulnerable situation, which moves us quite nicely onto the next slide. You might not realise, but there is an obligation on the creditor. So if you're aware that there's a potentially vulnerable situation, you should consider the appropriateness of referring debtors. So if you are aware of this and you alert us to it, it'll allow us to act in a more ethical and appropriate manner, and then we can make a more considered approach towards the enforcement. Obviously, we talked earlier about the 7 days notice before attending. It may be that in the meantime, before making an attendance, we'd write further to the debtor, or we'd give them an additional 7 days. You as the creditor or the client, you should always ensure that there are clear protocols in place with your chosen High Court Enforcement Officer. And should a debtor be identified as vulnerable, you should be prepared to take control of the case back in-house. As a group, High Court Enforcement Group will always report to you the details on any potential vulnerability, and then we'll take a considered stance on the appropriateness of enforcement. You should also make us aware, and you do have a duty to inform us as well on the other side, if the debtor may present a risk to the safety to the enforcement agent. Unfortunately, it's the nature of our business and what we do. You know, it's not nice turning up at people's properties looking to take goods or take their money. And unfortunately, sometimes our enforcement agents do come across unsavoury characters, and on occasions they do get assaulted. So if you can assist us in the outset and let us know of any potential aggressive situation, you know, it makes our job a bit easier. We can attend with a two-man team or maybe police assistance. So some obligations that fall on ourselves. So obviously every case is different and we have to take that on its own merit. And we have a duty to contact you as the creditor or client and report circumstances where there is evidence for potential concern. And then we also have to make a decision whether further action is appropriate. We should avoid taking action which could lead to accusations of inappropriate behaviour. And at the end of the day, it's our enforcement agent's certificate which is on the line. And obviously, we have a duty of care to the debtor. Now, enforcement agents should all be trained to recognise vulnerable debtors and to alert yourselves where we might have to withdraw from a situation. Here at High Court Enforcement Group, we're proud to say we have a multi-award-winning in-house training and development team, and all our enforcement agents are trained to recognise potentially vulnerable situations. We do also have our own in-house welfare team. So if you're sat there currently with a case and you're not sure whether to refer it for enforcement, we're always happy to take a call and discuss that with you. So at this stage, I think we'll conduct another learning review just to make sure we haven't sent anybody to sleep. And then we'll look at some case studies. So next question, which you should see on your screen now. Between which times can an enforcement agent attend a residential premises? Between 9 to 5 Monday to Friday, 9 to 5 Monday to Sunday, 6 to 9 Monday to Friday, 6 a.m. till 9 p.m. Monday to Sunday, or is it 24/7 providing that the debtor is at home? So we'll give you a couple more seconds before we close that poll down. Okay, so just over 3/4 of the people who've answered that poll question got that correctly. We can attend 6 a.m. to 9 p.m. Monday to Sunday at a residential premises. So the next poll question, where goods have been immobilised on a highway, what is the minimum time period that has to elapse prior to a removal? Is it 1 hour, 2 hours, 5 hours, 24 hours, or 48 hours? I think Jason did cover this earlier on the immobilisation and removal screen.
We've had a question on this as well from Sean, I think. Let me find it. She's asked whether we can remove vehicles from the driveway after 2 hours if the debtor is not present and has not been present at all. The answer is yes. You know, they've had our notice of enforcement. We would have conducted earlier attendances, so they'll be fully aware of our involvement. We first have to have an inkling that the vehicle is owned by the debtor, so DVLA checks or, you know, personalised registration. But no, the debtor doesn't have to be present for us to remove the item.
And it does also provide us with the correct answer. It is a 2 hour period. So the next question, which of the following items could be classed as exempt under tools of the trade? A drill set valued at £110, a small commercial van valued at £1,100, a large commercial van valued at £3,150, a family hatchback valued at £1,200, or a JCB excavator valued at £75,000. Now, again, there is more than one correct answer on this. Just a couple more seconds before we close the poll. Okay, so the answers were the drill set, the small commercial van, and the family hatchback. And then the final question we've got for you is under CPR 85.4, how long does the High Court Enforcement Officer have to inform the creditor of any third-party claims to goods? Is that 1 day, 3 days, or 7 days? It's a bit of a mixed reaction to this one. Just a couple more seconds there. Okay, Jason, if you want to close that poll down. So the correct answer was 3 days. We have 3 days to inform the creditor. It's the creditor who then has 7 days. So we're going to move on to some case studies. Now, believe it or not, some of these are, well, they're all real examples of questions that we've had hit our inbox. And because we've taken a number of questions throughout the course of the webinar and listed some for the end, we'll run through these very quickly. So firstly, can interest be applied above 8% if detailed on the order? Very quick and brief answer to that is yes, providing it is detailed on the order, sealed by the court, then we can make application and increase the interest on the writ. I've seen European enforcement orders at around 13%. So the next case study we've had, can you enforce against a company who have entered liquidation, but the director is a majority shareholder in another company of a similar name? I think this was one of yours, Jason?
It was, yeah. The answer is no. We can only enforce against the entity named on the court documents. So if that's a company with a specific company number, we can only pursue them. The director would have to be a personal guarantor for us to enforce against them personally. At the same time, they'd also have to be named on the court documents. If the company's in liquidation, there's not a lot we can enforce against. Next one, again, was one of mine. Can you remove chickens from a working farm, and would they be classed as tool of the trade? Now, believe it or not, we did some research, and a chicken is only worth between £5 and £10. So you'd need a fair amount of chickens to reach the £1,350 threshold, just a few, for it to not be a tool of the trade. Now, the farmer could claim up to £1,350 worth of chickens, but anything over and above that, we would be entitled to remove. You would have to consider the costs involved. We need a vet present to make sure they're all kind of vaccinated and healthy. We need specialised transport. We need somewhere to house them, somewhere to feed them, and we need to find a specialised auctioneer to sell them at a later date. So there are quite a lot of, extensive costs involved. So only if there was hundreds of thousands of chickens would it be something that we would look into removing. Sam, I think next one was one of your clients.
It was. So can you remove a swimming pool from a residential property? The answer is yes. We've just got things to consider. So the example that hit my inbox for this was a swimming pool in a back garden. So if we were to remove it, obviously we have to consider there's a massive hole in the debtor's land. We have a duty of care to the debtor, so we'd probably need to bring in a landscaper, maybe a gardener, to fill that hole. So we'd have to weigh up the costs of removing the swimming pool against the likely sale value of the swimming pool. Bizarrely, what I was told in this example, it was a flat pack swimming pool, which was packed up against the debtor's back door, ready to take. As it happened, we never ended up removing it. Next question, can you enforce whilst there is a third-party debt order in place? This is one that we get asked relatively commonly, and the answer is no. Obviously, the third-party debt order is a form of recovery in itself, so you can't recover the same debt twice against an individual debtor. Then Jason, I think the last two were examples you've had.
Yeah, one client, can you remove a vehicle simply to cause hardship to the debtor, despite it holding little value? It's not something we would normally do. Obviously, we have a duty of care for the debtor as well as the creditor, and we're supposed to be, ethical in the way that we enforce. If the asset is the only asset that the debtor owns, it's a car worth £200, by all means, we could pop a clamp on this vehicle just to cause a bit of an inconvenience to the debtor in the hope that it would prompt payment. When you're looking at removal costs, a recovery truck, maybe £250, plus auctioneer's storage charges, £10 to £15 a day on average, which I think answers one of Gavin's questions from earlier. You then got auctioneer's commission at 15%. It's really not worthwhile. If a client is absolutely adamant that they want us to remove a vehicle or an item, if it's not worthy, we would normally ask them to provide us with an indemnity to cover any out-of-pocket expenses. That normally puts the client off, because why would the client pay out of their own pocket just to disrupt the debtor? You normally find these questions come from litigants in person. It's quite a personal matter, and they just want to make the debtor's life a living hell, basically. And the final case study, before we move on to any questions that have come in today, one of our clients were holding an aircraft belonging to the debtor company. Could it be seized and sold to pay off outstanding work and storage charges? Now, as it happens, this company had a UK registered office, even though they were based overseas. So we could have served all the legal documents, court documents on the UK office. If there was no response or payment to that, we would then have to make an application to court to enter the third party premises, being the hangar that the creditor owned. It's not just enough to have their permission to be allowed on site. We then have to take control of the aircraft, issue all the relevant notices, give the debtor the opportunity to pay. But then yes, if payment wasn't forthcoming, the plane could be removed or sold on site, as we discussed earlier, probably by private treaty. Then any sale proceeds could be used in order to discharge the outstanding balance. Now, before we get to the questions, I'm just going to run over the next few slides very quickly. Obviously, you're all tuned into today's webinar, so you're well aware that we host 3 regular webinars, normally once a quarter. I think our next one is in a few weeks' time, actually, on the eviction of squatters and trespassers potentially. We offer free ebooks by email. These can all be downloaded via our website. We'll email you a link for the downloads. Today's ebook is in the handout section on the right hand side, which Sam mentioned earlier. So by all means, feel free to grab a copy of that, save it for a rainy day. Alternative services we cover, obviously judgment enforcement and tribunals we've covered in depth today. I've mentioned squatter and trespasser evictions. Again, any commercial repossessions, residential repossessions, rent arrears we can cover. We can forfeit the lease. We can recover any vehicles or assets that are owed under certain agreements. Serve legal documents on individuals. We can trace people who have absconded or if they're being difficult to find. And we're also a member of Connex. Connex is a group of companies across Europe. So each company has a link to an individual country. So effectively, we're a network of international enforcement companies. That brings us on to any questions for today. So let me just bring these up now, and then we'll
I've taken note of a couple as well.
Sam's taken note of a couple. So notice there was one answered early on by Gavin. So whilst the webinar's been ongoing, I've been trying to multitask, looking for the answer for you, Gavin. So been asked to transfer an ancillary relief order to a writ of control issued in the family court. Can it be issued for a writ? The order is for £68,000. So obviously we're talking about a lot of money. It falls well above the £600 limit. My understanding, the ancillary relief order, effectively it's only kind of a temporary measure in terms of enforcement. I think if there's any kind of default or balance outstanding, then a judgment would have to be obtained for us to enforce that. We would then just go down the normal route and look to enforce that under a writ of control.
One that I've taken note of, Jason, you might be happy to answer it. Can you remove assets if a company has ceased trading but set up a new company in exactly the same name?
This follows similar to the liquidation example earlier. So if a company, despite it being open again in the same name, we're looking for the entity. So we're looking for that company number of the original company. If the new company, well, they're going to have a different company number because they're new. They were probably incorporated after the debt was incurred. So no, we wouldn't be able to enforce against them. It has to be the entity that you've sued originally. I think, Sam, one for you that's coming from Darren. If a debtor has moved address and the neighbour says where they've moved to, can you accept this?
Well, Darren, we'll always take any intel that is provided to us by neighbours, and believe it or not, when we are knocking on doors and our enforcement agents are there in their stab-proof jackets with their body cams, neighbours are often peeping through curtains. You'd be surprised what information that they're willing to provide. So if they do provide us with an address, what we'd likely do is pass that through our in-house trace team, just to make sure that there are relevant links and the debtor is still registered to that address. Obviously, we don't want to waste any time sending notice to an address where they might have moved on from again. So we would take it on board, but we'd also make our own checks in-house. I hope that answers your question.
I think that's about it for the questions today. I mean, by all means, our contact details are on the screen. So like Sam said, we'll send copies of the slides and the recording out tomorrow, 24 hours later. If anyone does have any questions, by all means, drop us an email, give us a call, and we'll answer these where we can. But for now, I know we've overrun an extra 10 minutes or so. So sorry to anybody that's had to take an extended lunch break. But yeah, thanks very much to everybody for tuning in today. I hope it's been beneficial for you, and look forward to working with you in the future.
Thank you very much. Have a nice afternoon.
Cheers, everybody.